Hello, good evening and welcome to another episode of Law and Order on a beautiful Friday evening. Now, every week, as you know by now, we take a topic of law and get an expert to talk to you and educate you on this area. Now, we've all heard of this term fundamental rights, but often in layman's, we mix up fundamental rights with human rights. Is fundamental rights and human rights the same, or is it different? In the context of Sri Lanka, are we well protected from our fundamental rights, or are we not? Are there areas to development? These are questions that probably in your mind when it comes to fighting any issue of your daily life, which may you think it is a violation of your fundamental rights or your human rights. So tonight, let's go to the heart of the matter and let's talk to our expert and try to find out what this fundamental rights is all about. My guest today is a very special guest as always. Is Mr. Rajiv Amarasuriya, attorney at law, practitioner in Supreme Court and a specialist in the area of fundamental rights. Rajiv, thank you very much for taking time off and coming today for the show. How are you today?
Thank you, Chanakya, for having me on this program.
You're welcome. And like I said, it may be a confusing area for layman, commoners. Tell me to start with, what is fundamental rights?
Chanakya, fundamental rights are those rights which society considers important to include in a constitution in the form of entrenched rights. So we have several fundamental rights which are included in our constitution. And what is important about fundamental rights is that it provides a check and balance against state action. And then brings about accountability. Now, if I would like to advert to the relevant provisions which might be relevant. Section 3 of our constitution provides that the Republic of Sri Lanka, in the Republic of Sri Lanka, sovereignty is in the people and is inalienable. Sovereignty includes the powers of government, fundamental rights and franchise. So the apex is the people. Sometimes there's a misconception, you think the president, the prime minister, parliament, judiciary. But the power of the sovereignty, the power is vested in the people. The people delegate this power to the executive, to the legislature, to the judiciary. Then Article 4 goes on to say the sovereignty of the people shall be exercised and enjoyed in the manner, and they go on to say it gets delegated in that way. Article 4D provides that the fundamental rights which are by the Constitution declared and recognized shall be respected, secured, advanced by all the organs of government and shall not be abridged, restricted, denied, save in the manner to the extent hereinafter provided. Then we have from Article 10 onwards the several fundamental rights. Briefly, I will just take you through the relevant rights. We have 10, which is the freedom of thought, conscience and religion. 11 is that no one can be subject to torture, cruel and inhuman degrading treatment. Article 12, which we always make use of, as you know, all persons are equal before the law and entitled to the equal protection of the law. Then we have Article 13, which is no person shall be arrested save and except as provided by law. Similar provisions for detention. Then we have Article 14, which sets out several rights. The freedom of speech and expression, the freedom of peaceful assembly, freedom of association, freedom to form a trade union, freedom either by himself or in association with others, and either in public or in private to manifest a religion, worship, promote one's culture. Then also G is very important, the freedom to engage by himself or in association with others in any lawful occupation, profession, trade, business, freedom of movement, freedom to return to Sri Lanka, and the newest right we have, as you know, 14A, which is the right to information. So basically, those are the fundamental rights which are available in our constitution.
Right. Now, how does one vindicate an application of fundamental rights in court?
Yes. Now, again, I would like to advert to the relevant provisions, which is important. The relevant provisions are 17, Article 17, read with Article 126. 17 provides that the Supreme Court shall be vested with the fundamental rights jurisdiction. That is in respect of the infringement or imminent infringement of fundamental rights. Now, that is also important because you might have a contravention, a violation of fundamental rights. You might also have the reasonable apprehension that it is in the process of happening. So there is imminent infringement. So you can even at that point go into court. And it is also the enforcement mechanism is against executive or administrative action. Essentially, in layman's terms, that would be basically state action, action of the agencies of state. And then Article 126 provides that this mechanism is available to a litigant who comes within a period of 1 month to the court. And there's another important concept in this fundamental rights jurisdiction. Article 126(4) provides that the Supreme Court is vested in the power of issuing just and equitable directions. As you know, like in the Labour Tribunal, there is a just and equitable jurisdiction. So strictly speaking, the framework of the Supreme Court, when the Supreme Court exercises this apex jurisdiction, is not really the framework is not the law. They can go wider. It's a just and equitable. So you can look at concepts like reasonableness, fairness, legitimate expectation, violation of natural justice. So it's wide, and that discussion is vested with the Supreme Court. So basically, that is the process involved from the point of view of the provisions.
Right. Now, we all heard this word equality and equal protection under law. Now, tell us something about this. What is, who are equals, and how is equal protection of the law happens?
Yes, this is Chanakya provision now as a practitioner working in this area.
Yeah.
I think you also would have done some of these cases. Often it's one provision we always rely on. It has an overarching, it catches up lot of areas. And so the provision is all persons are equal before the law.
Right.
And are entitled to the equal protection of the law. But having said that, that doesn't mean every person is equally before the law in that simple sense. But there is this concept called reasonable classification. Reasonable classification, let me explain this to you by way of example.
Yeah.
Take for example a case where, say, the government gives a tax concession to a small industry in the northern province. That does not mean a large industry, say in another province, say specifically, say agriculture, small agriculture industry. That does not mean a large industry in another province, or a small industry again in another province may have the same, may be able to claim the same right.
Right.
So you group persons within you have a grouping, and the right and the equality is within that group. Now the test of reasonable classification in legal terms, if I tell you, that there are two tests, two conditions one must satisfy. The first one being that the classification must be founded on intelligible differentia, basically objective differentia, which distinguishes persons or things that are grouped together from others left out in the group. The second condition being that the differentia must have a rational relation to the object sought to be achieved. So equality works in that way. Then there is this other concept also, that there is no equality in illegality, which I must also add.
Yes.
Because sometimes I have had clients saying that so and so received this benefit.
Yeah.
Why am I not entitled to it?
Yes.
That doesn't. The equality is within the legal framework.
Yes.
You cannot say somebody was given something illegal outside the law, so give that to me too.
Yes.
So that concept also is in place.
Now, are there restrictions in enforcing or in the fundamental rights which you are entitled to?
Yes, the Constitution itself brings some restrictions. These are not untrammeled rights, and practically you can't give these rights in an untrammeled fashion.
Yeah.
So Article 15 sets out certain restrictions by law which the Constitution itself permits. Now, for example, I won't take you in respect of each right, but in general tell you, for example, in the interest of racial or religious harmony, or parliamentary privilege, contempt of court, defamation, then interests of the national economy, then also this is something with equality subject to national security, public order, protection of health, morality. So the Constitution itself says, well, these rights could be subjected to these restrictions. So the test is whether it's within those restrictions.
Right. Now, when you have filed a fundamental rights application, some X person has filed, if Y feels that why has the same right, or there's some kind of a order from the excess case might affect him, or some kind of a situation, is there right to intervene? Because
Yes,
you know very
yes.
clearly in other cases we can intervene.
Yes, yes. Say Article 134(3) provides for intervention.
Right.
So if you can, of course the court has discretion. So if you can go before the court and establish that there is you have affectation, or if the court grants this order, I would be affected, then you have the right of intervention. I must also point this out that sometimes there is a point of time you have to go in. Sometimes you can't, if you are aware that there is a case before the court, you can't wait towards just before the end of the case, just before judgment is delivered, and seek intervention. Then the court will say, well, you have come too late. So you have to go at the right time.
What if that person only got to know it?
No, then it's different. Then you have to go and establish before court that you have just got to know about this, you did not know, and now you have come before court at the earliest possible time.
Right.
You can't sleep over your rights.
Right. The normal concept applies.
Yes, so it applies.
Yeah, right. Now, I know you gave examples from Article 14 earlier. Can you just explain the broadness of Article 14? Because we just added one area for that, right to information as well.
Yes, on Article 14, every citizen is entitled to, and goes on, sets out from A to I, several rights. Now, at the outset, I must mention, now Article 12 provides that every person shall have, as opposed to Article 14, which says every citizen. So there was a time within our jurisprudence where the courts have held that citizen does not include a corporate entity, that it has to be individual.
Right.
And there were cases in the 80s where there were printing presses at which the case had been filed in the name of the printing press, and the court held that no, the entity was not entitled to his rights. However, of recent that has changed, and in fact in the coal tender cases, which I also appeared for some parties, the court held that as much as the Article 12, Article 14 also can be invoked by a citizen of this country or a company incorporated in this country. So
if I may interrupt you, the definition for citizen for 14 was expanded.
Interpreted in that way, I would think, yes. Interpreted in that way, I think citizen.
To include what?
Include even a corporate is incorporated in this country.
In this country.
Okay. So even a company.
But it doesn't apply to a foreign corporate body.
In terms of that judgment, if we go by that, then it doesn't.
It doesn't.
So these are, of course, evolving areas.
Evolving areas.
So the moment if we rely on that, it doesn't. So we have several rights: freedom of speech and expression, freedom of peaceful assembly, freedom of association, freedom to manifest one's religion. Those are from 10 onwards. Then, of course, this important right, freedom, which we again make use of for commercial purposes when we go before court. When a commercial interest or a right is infringed, then we cite 14G, the freedom to engage himself or in association with others in any lawful occupation, profession, trade, business or enterprise. So if those commercial rights are infringed by state action, then you would also invoke 14(1)G. Then we have, of course, freedom of movement, freedom to return to Sri Lanka, and the new right of the right to information, which is now evolving.
Right. Now, you've been a practitioner for a long time in this. Can you give us, if possible, some examples of the cases that you have appeared in fundamental rights, as well as, I'll couple this is another question, what is the most thickly contested fundamental right in your experience?
If example-wise, take I was in that case when there was a big. You might recall when for the A-levels you have the Z-score, and you have students admitted on that basis university. And in I think 2012 there was this issue where there was a problem with the old syllabus and the new syllabus. And clubbing these groups together. So I appeared with my senior, Mr. Sanjeev Jayawardena, for I think 350 or 400 students. We went before court, there were some other applications as well, and complained that the whole process is unfair, basically under Article 12(1). It is unreasonable. The court basically accepted what we said, but there was no rational basis on how those lists had been formulated. So ultimately the court intervened, and the university admissions were increased by I think over 5,500 numbers in that year on that basis. Then promotions. I've been involved.
Yeah.
Now even in the police force, I remember one instance where there was issue with a round of promotions, and they had granted on an ad hoc basis. So our clients who had more marks than those promotees wanted to go to court. So we went to court and complained and said it is unreasonable, unfair. You could not have done this.
Yeah.
And over 650, I think, police sergeants were promoted as police sub-inspectors.
Yeah, but from all the areas like Article
Yes.
14, 12 and all the areas,
Yes.
what is the most contested fundamental right?
12(1), which is used all the time.
All the time.
With its overarching
That's
effect.
equality.
Equality.
Yeah.
But equality is a concept which can be made use of, I think, in most occasions when there's unfair, when it's unfair, the treatment, unreasonable, when there's discrimination. It is 12(1) which we.
And these clients, most of the people who do this, most of them are just trying to make use of this provision with bogus applications, or were they genuine most of the time?
I of course have this principle that the client must pass my test first.
That's very good.
And
yeah.
I have had situations where sometimes I say no, there is no case, but then sometimes you see them in court with somebody else.
Yeah.
Where I believe that there's a cost involved and there's a time, everyone's time. So you cannot take frivolous applications to court. But you always get, those who are, but you don't come across them too often. Mostly they have a grievance. Sometimes it's not properly formulated, but there's a grievance.
Okay. There is a doctrine called public trust doctrine, you heard of. Can you tell us a little bit about this?
Yes, Chanakya, public trust, the executive power of the people is delegated to the executive. When the executive exercises this power, the executive is supposed to be accountable and exercise this power in the best interest of the citizen. So that is where the trust. So there is a trust reposed on the executive. When I say the executive, I mean the state agencies, the ministers, from the president downwards. So this executive power must be exercised in trust. Now I would like to have this quotation. This is not a new doctrine. This is the doctrine when Arahat Mahinda arrived in Sri Lanka. The first sermon he delivered to King Devanampittisa. He says, may I
Yes,
read this out? Your Majesty, the birds that glide the skies and animals that roam the forests have an equal right to live and move anywhere in this country, as you have. The land belongs to the people and all other living beings. You are only their trustee. So this is a concept coming from that time. I mean, the courts have developed it now, and in fact, Justice Veeramanthi cited this very same passage in opinion he gave in the International Court of Justice.
Right. There is other growing since late, I think last 15 years or whatever, concept of public interest litigation. What is public interest litigation and when does this arise?
Basically, as you know, to go to court you need to have a grievance, you have to have an affectation.
Right.
You have to have locus standi, we refer to in law. Public interest is where you are not affected directly, but you go in the interest of the public, in the interest of the your group, in your maybe the country. So the courts have developed this concept. It happened a lot in India. They developed this concept of public interest litigation. They allow citizens to come forward, groupings, maybe NGOs, to come to court and bring up national public issues and dispense with the requirement of standing. So that is public interest litigation.
In simple terms.
Yes.
Yeah. Now, a prospective client who wants to file an FR application, probably one of our viewers who are watching, are there any particular matters, technicalities that he or she should guard against before even talking to a lawyer?
Well,
or
yes,
no?
You have to go. You can go before a lawyer, but you need to know that the time frame. You have to go within 1 month. Another thing which I come across, which sometimes there is a misconception, is that sometimes litigants think, well, I can send letters, correspondence, administrative relief. You seek administrative relief. You go through a long process. At the end of it, you come and say, can I invoke this jurisdiction. The courts have held that if you elect to go down the road of administrative relief by sending letters, correspondence, it sometimes works. I'm not saying you shouldn't do that. But if you do that, then you disentitle yourself to come to court because you lose, you go over that 1 month. So that's another thing. Then also you have the Human Rights Commission. That is also a parallel institution which you can go and complain of a violation of fundamental rights. Of course, the difficulty in the human rights or the weakness in the system there is that the Human Rights Commission can only give a recommendation. And the recommendation is not enforceable. But often there are instances where litigants have got relief to the human rights, where the recommendation has been implemented.
Yes.
Then also, from fundamental rights point of view, if someone goes before the Human Rights Commission, the 1 month period stops. So you can, if you go before the commission, if once a recommendation comes, you can come back to court.
Right. What are the grounds that, I mean, this might be a broader question. What are the grounds that it might be a fundamental rights application can be refused?
Well, there are several grounds.
Yeah.
Let me first start by saying that this is it's a discretionary. It's not as of right. So the court has discretion whether to accept your application or not. It's not like going for the district court. It's not like going for the district court and filing a plaint which most likely will be accepted.
Yeah.
So the court has a discretion. So there are various grounds on which the discretion can be refused. Say, for example, if you don't come with utmost good faith, uberima fides, if you go and if you suppress material from court, you seek to mislead court, then you can be rejected.
Like an injunction. Yeah.
Right. Yeah. Then also you need to name your necessary parties.
Yeah.
Because you need to have your party. You can't go before court, keep the parties outside and see to get. When the objection comes, you can be thrown out.
Yes.
Then of course you have the time bar.
Yeah.
Then there are various other for example, futility. The courts will not accommodate a case which is futile. End of the day, if you are not going to get relief, they will. I mean, this is not a forum to go and make political statements. That sometimes happens, unfortunately. Yes. It's a legal process. So there are similar legal grounds which sometimes disentitle you to relief.
Okay. This question may be a little bit academic. Two questions what people always ask. Why is that, this is nothing to do with courts, it's the Constitution, has left it for 1 month period from the violation? And also, why is that only one court you have to go? For example, one court means you straight away go to the Supreme Court for fundamental rights. If the order is disagreed, unlike in any other case, there is no process of appeal. Like I said, it may be an academic question, but why do you think the Constitution enshrined it there? Or is it the same in all other countries?
No, I think you have sometimes you have longer periods to go into court. There are countries now, I think in India, where you can go at any time. There is, if I'm not mistaken. I think that the 1 month period to some extent is regressive because you are limited to go within that period. I think the thinking probably was that you need to have some consistency in state action. If you are allowed to challenge action several years down the line, then what happens to what you have already done? That probably would have been the thinking when they brought in the 1 month. But I think it should be probably a longer period. And also the court should be permitted in exceptional cases to go beyond that period, which actually through the public trust doctrine which we talked a little while ago, the courts have gone outside the time bar. Now in the Water's Edge case, Sri Lanka Insurance, it is well beyond 1 month. And they invoke the public trust doctrine.
The fact that there is no appeal?
That has its pros and cons.
Yes.
The positive side of it is that you go to the apex court.
Yes.
You have the determination of the most senior judges, the highest court.
Yes.
Well, having said that, there are benefits of an appellate process.
Yes.
If you go to maybe the next court, then you have obviously if there is some mistake. Everyone is human.
Yes.
People make mistakes.
Yes.
So if that happens, you have that opportunity. So well, there are pros and cons. Maybe the constitutional drafter should look at this. But there's another. Maybe you can have a separate court for this.
Yes.
Because also our Supreme Court is burdened with other matters sometimes, and then this takes a lot of time. Yes. So those are areas which maybe one needs to consider in the longer term.
Rajiv Amarasuriya, thank you very much for joining us. Thank you for those very insightful thoughts in a very large topic, which is important to all of our viewers. And thank you for joining
Thanks,
Law
thanks,
and Order
Shanak.
today.
It's my pleasure.
That's Law and Order for you today. We'll join Law and Order next week at the same time. In the meantime, you can go to our Facebook page, Facebook/Law and Order Channel I. That's Facebook/Law and Order Channel I, and post your comments or send us your messages as to what you would like us to have done for you through this program. Have a good night and a good weekend.